this case. So if tomorrow the prosecutor would say,
lorsque le président Gbagbo était enfermé à Korogo, il était enfermé de manière illégale, sans mandat, sans titre, sans que les dispositions légales et constitutionnelles ivoiriennes aient été respectées le moins du monde. Lorsque le président Gbagbo était enfermé à Korogo, ses droits de citoyen, mais aussi ses droits d'ancien président ont été violés constamment, continuellement. Il ne pouvait pas recevoir ses avocats, ne pouvait pas leur téléphoner, ne pouvait pas téléphoner aux membres de sa famille. Il était maintenu à l'isolement. C'était ça, la réalité de son enfermement à Korogo. Sous les yeux, disons les choses, de l'ONUCI, sous les yeux des autorités françaises, naturellement au vu et au su des autorités ivoiriennes, avec lesquelles le procureur était en contact constant.
On a regardé le document présenté par le procureur, le document contenant les charges, et on s'est en effet rendu compte que selon nous, il y avait des choses qui manquaient dans le récit qu'il faisait de l'histoire. Par exemple, il n'a pas pris en compte les origines du conflit qui existe en Côte d'Ivoire, par exemple le coup d'État de 2002. Il n'a pas pris en compte non plus qu'il existait un conflit avant 2010, donc ça c'est fondamental. Il n'a pas pris en compte que le président Gbagbo a à maintes reprises tenté de réunifier le pays. Il est allé jusqu'à nommer des éléments des forces nouvelles ou des rebelles, si vous préférez, au gouvernement. Passer ça sous silence, ça change évidemment la vision qu'on a des choses. Il est parti du postulat que Alassane Ouattara avait gagné les élections, mais il ne s'est pas intéressé au déroulé de ces élections, aux fraudes massives qui ont été dénoncées par les observateurs internationaux.
I read that the registry said, why don't you use the standard application format, you know, which was not used in Ivory Coast, so it was very confusing because people were presenting information that was not required for them or that would not qualify them as victims, okay? Now, this was very much criticized by the registry. My question here is are you aware of this lack of identification of whether these victims are representative of the crisis?
But of course, we know what we are doing, but the judges wanted to go faster. If you want to have a better idea of the victimization in that country, it takes time, money and staff.
But isn't it a waste of money to not use a standard application form?
There is no standard application form for that.
But this was...
No, the standard application form, it's for Rule 89, for further stage of the proceedings. For that, you use a different form, or you may not use any form, because it's not a real participation, as it is in Rule 89, it's just to present representation of victims of the situation. It's a different stage of the proceeding and a different purpose. But each chamber organizes the way it wants. That's the reality of this institution. And the Kenya chamber did not organize in the same way as the Côte d'Ivoire chamber. So there was not VPRS, the section was not ordered by the judges in Côte d'Ivoire to go to Côte d'Ivoire, to meet with people, so that to analyze who did what.
But the chamber did ask that representatives of communities more representative communities be present, and then I read that the prosecutor publishes a public notice in English in a country that's Francophone speaking 11 days before the deadline. Please explain to me how the communities in Ivory Coast are supposed to even know about what they have to do.
I fully agree. This is not the problem. The problem is that the judges didn't want to organize the participation of victims, the representation of victims in Côte d'Ivoire as was done in Kenya. That's the way it is.
But the judges were the ones asking for community representatives.
They must ask, because the victims have the right to make their representation at that stage.
But then why didn't they complain when they saw that this was not being done?
Because they said that we need to, I guess, that they wanted to proceed more quickly because in Kenya it took time.
But I remember Kenya, it's 110 days, and Ivory Coast, it's 30 days plus, considering that he arrived on the 27th of June, that the public notice was out on it's 1 month time, and the community one 11 days before the deadline. So it seems like they don't even want to see more than...
It does not allow such an extensive representation of victims as it was the case in Kenya. This is obvious. But that was the decision of the judges.
Of the judges?
But yes, of course.
Not of the prosecutor?
No. The decision on representation and the organization of the representation of victims is the decision of the judges.
So the judges are satisfied with this representation, considering that there are 700,000, 1 million refugees and they're not represented?
I guess they were.
They were.
Okay.